Good afternoon to all. This hearing is called to order. I'm Don Carrington, the hearing chairman of this panel. Also on the panel, are Dr. Anki Scott Joseph, Commissioner, Ms. Ron Martinez, Commissioner, Mr. John Griffith, Commissioner, Mr. Samuel Wallason, Commissioner. I would like to invite all persons who are participating, if you can kindly turn on your cameras. The commission is represented here today by Dr. Marsha Atherley Ikechi, the Chief Executive Officer, Mr. Kevin Webster, General Legal Counsel and Commission Secretary, Mr. Albert Scott, KC External Counsel, Mr. Roger Ford, KC External Counsel. Our stenographer today is Ms. Claudia Corbin, and I would ask Ms. Belinda Wood to swear in Ms. Corbin.
Good afternoon.
Good afternoon.
Claudia, do you swear or do you affirm?
I swear.
Please place your right.
Sorry. I'm not getting the audio.
You can hear me well now?
Yes.
Okay. Could you please place your right hand on the Bible, please?
Yes.
We'd like to see it.
Here it is.
Okay.
Thank you. Do you, Claudia Corbin, swear by Almighty God that you shall faithfully and truly record all the proceedings in this matter to the best of your knowledge and skill, and when required, produce a true transcript of same?
I
The stenographer has now been sworn in, Chairman.
Why did I think that I have?
As we requested of all persons that are participating, if you could turn on your cameras, please.
No, that's your camera, turn on your camera, together.
Able to. Okay. And I would now invite the applicant to enter appearances.
There are two people, something.
Good afternoon, Mr. Chairman and members of the commission, along with afternoon to the other representatives of the interested parties. My name is Kevin Boyce, and I'm appearing with Ms. Zaria Weatherhead of the firm Clark Gittins and Farmer on behalf of the applicant this afternoon. We do apologize for the absence of Mr. Ramon Aline KC. Representing the applicant this afternoon is Mr. Roger Blackman, Managing Director, along with Kim Griffith Town Hall. I believe you're muted, Mr. Commissioner.
Thank you, Mr. Boyce. I now invite the interveners, starting with the Barbados Renewable Energy Association.
Hi, good afternoon, everyone. I'm Stephen Worm, representing Barbados Renewable Energy Association.
We note the Energy Division has indicated that they are unable to attend today. Interveners, Ms. Trisha Watson and Mr. David Simpson.
Trisha Watson, entering appearances for myself, and Mr. David Simpson, my co-intervener.
Okay, thank you, Ms. Watson. Mr. Kenneth Lent.
Got it now. Thank you, Mr. Chairman. The opportunity, ending appearances for myself, Ricky Wright, Mr. Tony Gibbs, who is expected to join us, and Mr. Ade Stevenson. Unfortunately, Dr. Ali Alfar is in Egypt, and due to the time difference, he's not going to be able to join us today, and extend apologies.
Okay. The Barbados Sustainable Energy Cooperative Society Limited.
Good afternoon, Mr. Chairman and members attending. My name is Trevor Brown, representing the Cooperative Coalition. I expect to be joined by my co-intervener, Mr. Harley Haynes, sometime shortly. Thank you.
The Business Development Division.
Good afternoon, everyone. I am Jennifer Hunt. I'm the Acting Permanent Secretary in the Ministry of Energy and Business, Acting Permanent Secretary, Business. Due to unforeseen circumstances, there is currently no one assigned to the Office of Public Counsel.
Thank you. The Barbados Association of Retired Persons.
Good afternoon, all. I'm Marilyn Rice-Boyne, and with me today is Doug Skeet, also from Bar.
Okay. Thank you. In the matter of the Utility Regulations Act, Cap 282 of the laws of Barbados, and in the matter of the Utilities Regulation Procedural Rules as amended, and in the matter of the application of the Barbados Light and Power Company Limited for a review of electricity rates, and in the matter of the decision of the Fair Trading Commission issued February 15, 2023. On March 7, 2023, in accordance with Rules 8, 53, 54, and 55 of the URPR, the Barbados Light and Power Company Limited, the applicant, filed and served notice of a motion to review and vary the Commission's decision dated February 15, 2023. The applicant also requested a stay of certain orders made by the Commission in its decision. In accordance with Rule 4 of the rules, the Commission issued procedural directions number 1 on March 16, 2023 to the applicant and interveners. The procedural directions invited all interveners to make written submissions in support or against the granting of the stay and permitted the applicant to respond to those submissions. Interveners were also given the opportunity to respond in writing to the substantive motion, and the applicant was permitted to reply. On May 12, 2023, the Commission issued its decision on the request for a stay and ordered that paragraphs 400, 401, 404, 405, and 407 of the February 15th decision be stayed until the determination of the applicant's motion for review and variation. On May 24, 2023, the Commission issued procedural directions number 2 to all parties and advised that in accordance with Rule 36, the motion for review and variation will be disposed of by way of an oral hearing set down for 3 consecutive business days, commencing Wednesday, June 14, 2023, and concluding Friday, June 16, 2023. By notice of motion dated and filed on June 5, 2023, The applicant requested that the commission amend its procedural directions number 2 and adjourn the consolidated hearing that had been set down for June 14th to 16th on the determination of the threshold test and the motion for review. To ensure all parties had adequate notice of the hearing of the motion to adjourn today, the commission at the close of business on Monday, June 5th, issued a notice of hearing to all parties. Parties are reminded of the rules of etiquette that has been provided to them. Virtual hearing etiquette. All parties shall conduct themselves in a respectful manner. Conduct that is contemptuous by any person appearing at this virtual hearing shall be grounds for excluding that person from the proceedings. The commission shall control the pace and flow of the hearing and shall do all that is necessary to ensure there is a smooth and efficient flow of proceedings. Parties are, however, asked to abide by the following. Parties should be prepared to join the hearing at least 10 minutes before the start to allow time to address any technical or connectivity issues. On joining the hearing, parties must ensure they can be properly identified by the commission and all other parties by their full names. Please make reasonable efforts to find a quiet, private, and well-lit space for the duration of the hearing. Ensure that you're clearly visible by maintaining a reasonable distance from the camera to show your head and upper body. Ensure the documents you need are organized and prepared in advance. Ensure that you mute your microphone when you're not speaking. Remember to unmute your microphone only when it is your turn to speak, and to do so directly into the microphone. Use the raise hand button in Zoom if you feel absolutely compelled to interject or interrupt a speaker. Upon raising your hand, please then wait until you're called upon to speak and refrain from speaking at the same time someone else is speaking. Please do not eat during the hearing. Dress appropriately if you are attending in person. Okay. So we now will deal with the motion before us. This motion will be heard as follows. The applicant will be given 10 minutes to present its motion, interveners 10 minutes each to respond, and the applicant 10 minutes to reply. After all submissions, the commission will take a break to deliberate and return its decision on the motion. And you would be invited to join the Zoom link at that time. So I now invite the applicant to present its motion.
Thank you, Mr. Chairman. Sir, the motion of the applicant, as stated, was filed on the 5th of June, 2023. Prior to that document, sir, written correspondence was sent from the offices of the attorneys representing the applicant, setting out preliminary notice of the unavailability of Mr. Ramon Aline for the date set by the commission. Subsequent to this communication, sir, our records indicate that there was a correspondence sent by Mr. Wendt, and our records also indicate a document received from BARP enclosing an affidavit of Ms. Marilyn Rice Bowen, sir. Sir, the nature of the motion is a motion pursuant to Section 36 of the Fair Trading Commission Act. And the motion is before the commission, and I believe circulated through all parties, and seeks an order that the commission exercises power under Section 36 or otherwise to amend, review, and or various direction or instruction issued by procedural direction number 2 dated the 24th of May, 2023. And I think it important, sir, to reference, as you have done, the fact that there were 2 procedural directions issued this year, and which those documents dealt with specifically the applicant's motion for a review of the decision in relation to the rates, sir. The first procedural direction, as you have referenced, was on the 13th of March, 2016. And it's important to note what that direction relates to, sir. That direction relates to the hearing of a motion for review and variation and the request for a stay of the implementation of the decision. What is particularly of import, sir, is that at 4 of that motion, the commission stipulates that it will in general seek to enforce the timelines, but will make modifications where circumstances warrant. We say, sir, that the motion which is sought today is one such circumstance, and we will get to why a little later on, sir. Now, sir, the grounds for the motion are set out within the body of the motion and supported by a sworn statement of the deponent, Mr. Ramon Aline KC. It sets out that the grounds on which the motion made is that Mr. Aline is scheduled to be out of the island for previously made business arrangements. And secondly, and sadly, due to the death of his father, he is actually today dealing with the first part of putting his father to rest, and the latter part will be conducted in the earlier parts of next week. On the basis of these facts, sir, the applicant's legal counsel will not be in a position to attend the date set by the commission for the 13th to the 15th of June. However, while understanding the import, Mr. Aline has set out his available dates 9 business days later, which is from the 26th of June, 2023 onwards. Sir, it is one of those circumstances where we understand perception and we understand reality. The fact is, sir, that the commission has stated its power and it has referred explicitly to the statutory regime under which it operates. So what are the circumstances which the commission finds itself faced with in which the applicant seeks the order before it today? The first thing, sir, is that the dates which were set without consultation with any of the parties. Now, let me hasten to add, this is not an indictment of the commission or what was done. It is just simply a reality that the parties had no notice of the dates which were set forth. The commission is, of course, aware of its mandate for reasonableness and its process and its duty, which it has carried out explicitly to be fair to the parties and consult as necessary. Of course, the members of the commission would be advised by their legal counsels and may be so aware that under Section 4, the Fair Trading Act requires the commission to consult when performing its functions. And of course, the commission's rules under which it operates provide that Rule 35D provision for conferences to settle dates for hearings in relation to rates. The fact is, sir, the commission had previously exercised this consultative process to set dates prior, which were found to be convenient to the respective parties for matters which required arguments and presentations. This, of course, an example could be drawn, sir, in relation to the hearing that was done under a different procedural direction, sir, on the August 22nd hearing last year, which facilitated the hearing dates and the disposition with regard to the rate hearing. And I will call it the substantive rate hearing. So the first circumstance the applicant wishes to draw to the attention of the commission was that the applicant cannot be said to be contumelious in relation to its conduct because it did not have notice of the date. Secondly, sir, there for the grace of God goes any of us having to deal with death of a family member. These are the reasons, the first set of factual matrix that we wish to draw to the attention of the commission. We say, sir, that when that is considered, along with the commission's practice and statutory powers of consultation, that hindsight, of course, being 2020, if there was such consultation, albeit say for the aspect of the death, there may have been an ability to find a convenient period. The second point we wish to draw to the attention, sir, is that while there will be some delay, if the commission is so minded to grant the adjournment sought of 9 working days, the commission has already found, as a matter of fact, in its decision in relation to the issue of the stay granted on the 12th of May, 2023, and I quote, sir, from that decision, that the commission found that the public is reasonably and adequately protected by the terms on which the interim rate relief was granted. We say, sir, that a further 9 working days as sought by the applicant will do no harm to the public, especially as the commission has found that they are adequately protected by the terms of the interim rate relief. Secondly, sir, the delay itself is a short period that is being sought, and the reasons why it's being sought should also be a factor we submit, sir. Fourthly, the commission would have noted in its stay decision that the financial and monetary nature of the challenge is a factor, and we say, sir, a circumstance which the commission should consider in relation to the adjournment sought. In other words, the applicant, who the commission has recognized has $99.5 million under dispute and a further $9.5 million under dispute in relation to the decision, ought to be entitled to have its lead counsel able to make its representation. That statement of the financial and monetary nature being a factor is taken from paragraph 28 of the decision of the commission in relation to the stay. Finally, sir, on somewhat of a emotive level, I believe that we have a way of doing things in Barbados, and it is simply, dare I say, proper to allow a very short period for Mr. Aline to be able to grieve the loss of his father. There, for the grace of God, goes any of us, sir. Sir, I have no further statements in relation to the applicant's formal application. I will reserve, sir, in terms of any counters for response, sir.
Okay, thank you. I will now invite the interveners, starting with the Barbados Renewable Energy Association. I have 10 minutes in which to respond.
Thank you, Chairman. Good afternoon to you and all the commissioners and staff of the Fair Trading Commission and representatives from Light and Power and fellow interveners and everyone else that's attending this afternoon. We thank you for this opportunity to give our view on the rescheduling of the hearing date for Light and Power's motion to vary the Commission's decision on the 15th of February. So far, we've only seen one objection to the adjournment of the hearing and one tentative agreement based on when it can be rescheduled for. It is our view that with so many things that are going on for many of us on this call, you'll not find a perfect period for this or any other hearing in the near future. In our view, the interveners have played a very important role, and I expect will continue to make valuable contributions through the remainder of the process. So where possible, their availability for the date set for the hearing should be carefully considered. However, despite our important role and whether we all like it or not, the two critical players in this process are Barbados Light and Power and the Fair Trading Commission. And I cannot see any hearing proceeding without the full representation of either of these two parties, especially if, as in this case, Light and Power's leading counsel, who is their main spokesperson, is not available on the dates proposed, especially at the stage that we are at in this process and the nature of the motion that we have before us. We therefore support the rescheduling of this hearing to accommodate to their availability. With regards to the new date, while I believe that every effort should be made to accommodate everyone, if this is not possible without delaying the hearing beyond a reasonable time frame, maybe not more than a month, I would imagine would be reasonable, we would recommend that the Commission select a new date that would be suitable to themselves, Light and Power, and then as many interveners as possible. Thank you very much, sir.
Thank you, Mr. Worm. The intervener team of Watson and Simpson.
Thank you, Mr. Chairman. To everyone present, the applicant, fellow interveners, members of the Barbados media, Chairman Carrington, Commissioner Joseph, Commissioner Wallison, Commissioner Griffith, Commissioner Martinez. In making our submission regarding whether the applicant's motion to adjourn the hearing that had been set to commence on Wednesday, June the 14th, 2023, should be granted or denied, the Watson and Simpson intervener team respectfully submits that this decision has already been made and that will not change as a result of this bit of theater. The CEO of the Fair Trading Commission, also a commissioner of the Fair Trading Commission, in her official capacity, was featured in the June 1st, 2023 Barbados Today, by no means a minor news publication, stating unequivocally that the hearing of the applicant's motion for review has been delayed. The Commission has never refuted that statement, nor asked for the article to be corrected. We do not know why the Commission is engaging in this process today, having already made and publicized that decision. We do note, however, that the Commission continues to disregard the law set out in the Utilities Regulation Procedural Rules. We also note that the Commission continues to treat interveners, clients of the Commission, with an appalling level of disrespect. This does not reflect on us. Since the case started, the Barbados public has been expressing its concerns about whether the Fair Trading Commission is acting fairly in this process. Whatever you choose to do at the end of this particular hearing, we, this intervener team, intends to speak to the people of Barbados because this is their proceeding. We, the people of Barbados, must pay the costs of this proceeding. We must pay the applicant's costs. We must pay the Commission's costs. We must pay any costs that are awarded to the interveners. And then if you choose to award an increase to the applicant, we must pay the cost of those increases directly and by the increase of the cost of goods and services in this country. What Light and Power has proved indisputably in this rate case, and which even the Commission acknowledges by its February 2023 decision, is that the Barbados Light and Power does not deserve a rate increase in this matter. In fact, it has proven that it owes hundreds of millions of dollars to the people of Barbados. There are several good arguments, Mr. Chairman, that could be considered for not unnecessarily delaying these proceedings at this critical point. Council is correct, and Bria is correct. We do not need another delay, and this intervener team is ready for June the 14th. The Barbados Light and Power has repeatedly represented that it is prejudiced by delays. In fact, the Barbados Light and Power tried to use that same argument to convince the Commission to exclude this intervener's team's 83-page response to its request for a review. They're clearly nervous. That's obvious to me. I think it should be obvious to anybody who's involved in this process, likely because they know that their case is weak, that their maneuvers thus far have not worked, and that due to the efforts of the interveners that are representing consumers and ratepayers in this matter, they have not succeeded in convincing the Fair Trading Commission. The Fair Trading Commission has said that themselves. Mr. Chairman, no doubt in your decision, the Commission's decision coming out of this hearing, the panel will protest our assertion that the decision on this motion has already been made public. I can see frowns already on the company's side. And you will protest that this process is a performative gesture for the Commission to pretend that you have followed the prescribed rules. You have not, in fact, followed those rules. The Barbados consumers and businesses that are looking on can read for themselves, and they would have read that article. It was clear. The interveners in the main have not whined and complained and gone to the media about it. We do not have the budget to throw in to that kind of PR campaign. What we have done, however, Mr. Chairman, is to set aside the time. And the Fair Trading Commission, having taken 5 months with a full staff to review the hearing and come up with the interim decision, understands the resources that are needed, understands the constraints on interveners, because we either have no staff or minuscule staff. The Commission is aware of the applicable utilities public regulation procedural rules, and that Rule 30 mandates that the Commission may adjourn a hearing from time to time, either on its own initiative or upon a motion by a party, and on such conditions as it considers appropriate, the Commission considers appropriate. Therefore, when on June the 1st, 2023, the Commission communicated rather euphemistically that it had rescheduled the review motion, it did so unlawfully on several counts. Number one, it acted on the basis of a mere letter, not a motion, from the applicant. And that letter came not from a party to the proceeding, but from the legal firm representing the party. The party is the Barbados Light and Power. And further, by failing to require the requesting party to submit that notice of motion, the Commission then breached several more requirements contained in Rule 8, and then went into the public and made an announcement. It serves no purpose in the short time that you have given us today. I also want to register my complaint about that, the Commission not having given us any notice of how this particular hearing would be conducted. It serves no purpose in the short time available to list all of the breaches that have occurred in this matter. They're too numerous to mention. And the Commission is clearly aware of its actions by organizing this short notice hearing. The suggestion that we had a lot of notice is a nonsense, Mr. Chairman. 3 days is not a lot of notice. No, we are not here to challenge a decision that the Commission has already made privately and publicly announced. That is history, that's water under the bridge. We are here to ensure that we go on record stating that the Commission must, in setting new dates, take into consideration the availability of all of the parties in this rate case. That means the applicant and all of the interveners. I am stunned at the suggestion by intervener Bria that some can be shunted aside because they might not be available. That is an abhorrent suggestion, Mr. Chairman, and I urge the Commission to reject that suggestion. Contrary to what it has done throughout this hearing thus far, the Commission must weigh the parties' availability equally. In this respect, the applicant and the applicant's counsel are not more important than the interveners representing Barbados's consumers in this matter, nor are any of its witnesses. Furthermore, the Commission must also rule that it has reversed the position used by applicant's counsel to oppose the Public Counsel's request for an adjournment earlier in this matter. that quote unquote, all parties are to have multiple representation in terms of the nature of these proceedings, because clearly that has been put aside. Because the fact is, the applicant has multiple legal resources. The firm representing the applicant has no less than 22 attorneys at law. So they too have multiple resources, certainly far more resources than the interveners in this matter. And so again, I will use the term, it is abhorrent to suggest that they can request an adjournment on the basis that one counsel is not available, but the rest of us will be expected. If a main or leading intervener, a spokesperson is not available, then too bad, the matter must move along. As the matter stands, the commission, presumably is aware of the availability of commission staff, as well as the availability of commissioners. Your CEO has already made comments about that in 1st of June Barbados Today article. And various documents recently made available to interveners, including the Clark-Gittins and Farmer letter and the Ramon Aline affidavit, the applicant states on no fewer than 5 instances that Mr. Aline will be available for June the 26th, therefore putting into the commission's head a date to set today. That's all well and good. But notwithstanding the statements that have been made about going back to the drawing table with dates, we are demanding that the commission take all interveners' availability into account in setting dates for this matter. It cannot ride on what is convenient only for the applicant and applicant's counsel. What we are certain of also, Mr. Chairman, is that Mr. Wendt has made it very clear that he must appear as the applicant in a superior forum. The High Court of Barbados, he has said it repeatedly during this proceeding, and he has written to the Fair Trading Commission about it twice since Clark-Gittins and Farmer wrote and said that they would be available on the 26th of June, and he has been explicit about that date.
Ms. Watson, remember
Chairman,
we were giving you 10 minutes and you have exceeded those 10 minutes. If you can just wrap up in 1 minute.
By all means, Mr. Chairman, that is not difficult for me. We are submitting to you, Mr. Chairman, that you must take into account the availability of all interveners. We, Mr. Chairman, reject any effort today to set dates. We are insisting that the Fair Trading Commission must set a procedural conference. Counsel for the applicant has already endorsed the idea of having a procedural conference specifically to set dates, and that is what we are requesting, Mr. Chairman. We are also putting the commission on notice that this intervener team will formally oppose any attempt to consider this notice of motion for review and variation by a written hearing. We are insisting that this matter must be addressed in a fully public oral hearing in the full light of day. We will not accept any secrecy. We will not accept a written hearing, Mr. Chairman. The matter has been ventilated by public oral hearings thus far, and that is what we are insisting on. We will not participate in any such attempt that may occur to make this a secret matter. We are putting the commission on notice that in the interest of the people of Barbados, the intervener team of Tricia Watson and David Simpson will vigorously resist any written hearing of the applicant's motion for review and variation of the FTC's February 15, 2023 decision, or any other aspect of this rate case for that matter. Whatever you choose to do at the end of this meeting, Mr. Chairman, we will speak to the people about Barbados because this is their proceeding. We reserve.
Yes, thank you for your submission. Thank you for your submission, Ms. Watson. Okay. Mr. Wendt?
Thank you, Mr. Chairman. Please, good afternoon to all. Please permit me to proceed on the basis that protocol has already been established. With the passing of his beloved dad, this must be a very tough time for Mr. Allen and his family. On this day, 4 years ago, I laid my father to rest so I can feel Mr. Allen's pain. May he rest in peace. May dad rest in peace. I intend to attend that funeral on the Monday, the 12th of June at Cornwallis during the Thanksgiving service for Mr. Allen's death. Now, with respect to the motion to adjourn, our team's attention to several instances where the commission granted flexibility in virtually all parties. As evidenced by our letter of the 16th of May, 2023, BLPC was a beneficiary in 4 of the 10 times that the commission granted accommodation. Mr. Chairman, you will recall that the said corresponds with standard when BLPC filed an affidavit to disregard the response of an intervening team of Watson Simpson to its motion for review. Therefore, in general, our team supports granting flexibility for very, very good reasons. As you've pointed out, the commission set the 14th to 16th of June 2020 for the public BLPC's motion to review its decision on the 15th of February. All available information suggests that the dates, that's 14th to 16th June 2023, are convenient to all parties, which is the FTC and its staff, interveners and our supports, the BLPC's management and staff, the BLPC's consultants and experts, the BLPC's legal team, apart from Mr. Allen. Everyone is available in the proceedings apart from Mr. Allen. The situation is almost identical to what prevailed at the start of the public hearing in September 2022, when all parties were ready to commence presentation and cross-examination, apart from the acting public counsel, who had only been in the post for 3 days. A motion to stay was denied. Now, notwithstanding the previous ruling, and what we firmly believe is a similar circumstance, Mr. Allen is asking that the dates of 14th to 16th June be shifted onto the 26th of June or thereafter. However, in our letters of the 31st of May and the 5th of June to the FTC, we reiterate that the trial of our class action suit, Kenneth Wayne et al. Versus Kevin Wallace et al., that started on the 6th of March, is set to resume on the 26th of June in the Supreme Court. Further, it was pointed out that the trial is projected to continue until the 21st of July. So consequently, while our team is always willing to be as flexible as possible, we are unable to support a position that would compromise the 300+ minority shareholders who have been striving to seek justice and equity for 5 years. Now, in addition to the foregoing, it was pointed out that Mr. Allen and his colleague, Senator Kevin Boyce, are also representing some of the defendants, Liberty Global, to be specific, Liberty Global and Kevin Wallace West Indies Limited, in the said class action suit against Kevin Wallace. While our team has no intention to dictate how Mr. Allen, Senator Boyce, and other lawyers of the Clark Denison Farmers firm organize themselves to serve their clients, Mr. Chairman, it seems that there are several options available to allow the dates of 14th to 16th June to remain. One, since Senator Boyce has been working closely with Mr. Allen, is there any reason why Senator Boyce could not take the lead during the 14th to 16th of June if Mr. Allen's business travel was inevitable? Two, alternatively, could Senator Boyce hand the business travel and allow Mr. Allen to contribute to be leading the BLPC case during the 14th to 16th? And three, if the FTC is to grant flexibility, then could all parties compromise to arrive at a 3-day window that coincides on or concludes on or before the 26th of June, which would allow suit still to continue on the 26th. The other, another option would be if the applicant wish to withdraw the motion to adjourn. And if I was wicked, I would say if the applicant was mindful to withdraw the motion for review following a solid decision by the FTC, but I wouldn't go there. Mr. Chairman, our team is of the view that Mr. Ali's request mirrors the position of the acting public counsel at the start of the hearing, so the same ruling should apply. If there's any concession due to the death of Mr. Ali's father, then our team would not be averse to the date shifting by 1 week. And in so doing, Mr. Ali would equally have to modify his business engagement to be handled virtually or at a later date, or allow Senator Boyce to provide the requisite relief as they both consider appropriate. That I would leave that today. Now, since the class action suit is set by the court to continue from the 26th of June until the 21st of July, this time frame must be regarded as a blackout period, especially since the case has been going for 5 years. Equally, the BLPC's review has been going for what, nearly 2 years now. So it is not reasonable to ask ratepayers, nor the FTC, nor the commission to wait longer, and of course, interveners text, spend more time and cost on this important. Mr. Chairman, I trust that our submission would be useful in helping the commission to arrive at its final decision. Thank you very much for obliging me.
Thank you for your submission, Mr. Wright. The Barbados Sustainable Energy Cooperative Society Limited.
Good afternoon to you, Mr. Chairman, again, and to members of the commission, also to representatives of the applicant, the fellow interveners, the staff of the FTC, and indeed to all those present and attending. It continues to be an honor for the Cooperative Coalition to participate in what we consider to be this very important national process. And in so doing, to represent and to articulate the views, the concerns, and the interests of our over 200,000 members, particularly, sir, those members whose voices have traditionally been excluded from exercises such as this. It would therefore, sir, be remiss of me not to raise our grave concerns that this process, having commenced back in September of 2021, nearly 2 years now, with a simple application for a rate review by the applicant, continues to be unresolved at this time. No doubt, Mr. Chairman, you would agree with this, that given the unambiguous stipulation expressed in Section 19(2) of the Utilities Regulation Act, the law of Barbados, this situation does not convey to my members a sense of professionalism that is expected at this level of public life in Barbados. And sir, since I'm being open and frank here, let me also say how disappointed we have been as a coalition to see the level of disrespect that we consider to have received during this whole exercise. And I will explain what I mean by that, sir. You must be aware, sir, that today, we in the coalition have not had the simple courtesy of having formally met with you and members of your commissioners, with the applicant's representatives, or even the staff of the FTC. We have not had an opportunity to participate in any kind of informal session, which was designed to discuss and agree on basic procedures to be followed, ground rules to be applied and to be observed, and limits to be exercised. All these things happen in very formal atmospheres with real legalistic back and forth. We have complained continuously about the Commission's lack of response to 2 motions, for example, filed by the coalition, which appears, sir, to have been filed in your 13th file. Trust me when I tell you this, sir. The cooperative movement is to be ignored at the Commission's peril. I believe that the need for this specific hearing is a clear example of how having a simple technical conference that established ground rules, agreed timetables, procedures, would have made this whole hearing exercise from the very beginning much more efficient. As the applicant correctly expressed in the letter of 5th June, Participants in the matter, including the Cooperative Coalition, had no prior warning of the date set down by the Commission for the hearing, and therefore no opportunity to indicate unavailability or availability. Interestingly, this has not always been the case, and there have been examples when there was consultation, so there has been no consistency. There have been different approaches used by the Commission. In our opinion, this is not even a matter of simple courtesy on the part of the Commission, but one of professionalism and efficiency. On the other hand, with respect to the applicant's request for a change in the dates identified, however, we in the coalition strongly disagree with any changes based on the circumstances outlined in their motion. In previous positions taken by the applicant and by their legal representative, Mr. Aline himself, they articulated very strong views that, quote unquote, time was money, and that the process must not be delayed because of individual circumstances, and that interveners and participants should make arrangements for substitutes where needed. Indeed, sir, we recall Mr. Aline's strong objection to a request that public counsel be granted some time to get up to speed after unceremoniously having been dropped into that office in a matter of days. Sir, counsel even expended great efforts in counting the number of times that the coalition made particular points to ensure that we did not waste time by repetition. Now that the ball appears to have landed in his court, the applicant seems to be crying foul. This, sir, when the applicant is represented with the backing of a full, well-compensated legal team that should be more than competent to proceed with this matter with or without his assistance. But over and above that, Mr. Chairman, the Commission has approved, has allowed, and have endorsed technology that would allow him to take part in this business, in this process, even if his business is somewhere off planet. I close by suggesting, sir, that the Cooperative Coalition therefore supports the expediting of this matter, which is already way overdue, by continuing with the dates that have been dictated, and I use that word deliberately, sir, by the Commission, and we reject the motion proposed by the applicant. Thank you very much, sir.
Thank you, Lieutenant Colonel Brown. The Business Development Division.
Thank you, Chairman. Good afternoon, all. The ministry has no issues with the granting of an adjournment. It will, however, abide with the decision of the Commission. Thank you.
Thank you, Mrs. Hunt. The Barbados Association of Retired Persons.
Good afternoon, Chairman. The members of the Barbados Association of Retired Persons, as you can understand, are very interested in having this matter resolved as soon as possible. They're the ones who have been at a disadvantage in having to pay the increased interim rates and are keen to have a decision in this matter. Mr. Chair, I have similar interests as indicated by Mr. Wendt. And so therefore, I don't need to go over the points made. I do have an interest in the hearing the cable and wireless suit. And therefore, the requests for the change dates from the 26th of June for 9 days will have some impact on me. As I indicated, I'm also part of that suit that is going to restart, as Mr. Wendt indicated, from June the 26th. So I do agree with the points put forward by the other interveners that clearly the applicant's attorneys have at their disposal significant resources that they can call on that should not in any way impact on this hearing because of Mr. Alleyne's absence. We certainly should be able to continue this hearing on the dates that were specified. And there's absolutely no reason why Senator Boyce, in this instance, who's been in this hearing from the very beginning, should not be able to take over from his senior colleague. So the members of BAR are certainly not keen to prolong this hearing any further. And to that extent, and in my own position, I am saying that the class action suit that is going to be restarting on June 26th, that will last until June 21st, will make it extremely difficult for me representing BAR to be engaged in this hearing if it is rescheduled during that period of time. Mr. Wayne has suggested that you may want to look at a period of time before before June 26th, and I endorse him in that comment. So without prolonging this any further, Mr. Chair, and without repeating what the other interveners have said, I totally agree that this hearing can continue in the absence of Mr. Alleyne, and I don't see, or BAR does not see, any harm that can come to the applicant if that has to be done. Thank you, sir.
Thank you.
Hearing you, Mr. Chairman.
Okay, so we have the response from the applicant.
Thank you, Mr. Chairman. Sir, I think the starting point should be I think it's been repeated by 3 or 4 of the persons who spoke. There seems to be a conflation of the application made by the representative for the Office of the Public Counsel to what is being sought today. Sir, there are 2 entirely different circumstances. Firstly, by procedural direction number 6, paragraph 16, in the hearing to deal with the rate increase. Actually, let me take a step back. This is not the same hearing that we're dealing with today that was the hearing which dealt with the rate increase. There are 2 separate matters by which separate procedural directions have been issued. Procedural directions which were set by the commission as to how the matter is to be conducted. We think it's unfair to attribute a determination that was made in a procedural direction for another hearing to this matter, which is a review of that hearing. So that's the first misconception, sir. Sir, in the hearing to deal with the rate increase, a specific direction, procedural direction number 6, paragraph 16, stipulated that the commission specifically indicated to all parties that they are to have multiple representatives in terms of the nature of the proceedings. No such direction was given in procedural direction 1 or procedural direction 2 of this matter. This is a new matter. There has been no direction, sir. Sorry, let me lower my tone, sir. There has been no direction, sir, with regard to the use of multiple representatives. That was for the rate hearing. We have passed that. The applicant has complied with the directions set out by the commission. When the applicant saw that it was unable to comply with a date that was set, it immediately wrote and it filed an application. That has to be contrasted with what happened in the other hearing, where there was a hearing which was set to determine the dates. Persons from the public council attended that hearing, agreed to the dates that was set. They were given time to get their house in order and attend for the substantive hearing with regard to the rate review. Then turned up, and we had complete sympathy for the person of Ms. Sharon Dean. But the question was, sir, the question of the office, which had the responsibility and had notice of the hearing there well in advance. It is disingenuous for anyone to paint the two things with the same brush. It is clear also that a review of the procedural directions would bear truth to this. And the same excerpt that was quoted by Bark in relation to Mr. Ali's statement, which is derived from the transcript, sir, if the commission is minded to review it, bears truth to that statement. Sir, I come in here, I know my role. I sat down, I played a role in the rate hearing, sir. Any observer would see, sir, I was brought in for the evidentiary argue. They tell me I'm a trial lawyer. I stay in my lane, I dealt with evidence, sir. This review has been championed by Mr. Aline, who is the attorney at law of choice for the applicant in this matter. There was no indication that the applicant was supposed to have multiple representatives. Mr. Aline was traveling and his father has died, and we took the steps to come before the commission as soon as possible and say, these are the circumstances. Can we have 9 days? Can we have 9 days? To seek to conflate that with the period sought by public counsel when they had previous notice of the hearing is unfair and extremely unfortunate given certain of the parties who are making the comparison, sir. And when we look at it, sir, in relation to the procedural guidelines and notifications, we are very clear that there has to be a difference in adjourning a rate hearing where you have to deal with logistics, personnel, facilities to have the rate hearing, equipment, Zoom, catering, experts, venue, and prep, and to compare that for a review, which is an intellectual exercise to be carried on by the lawyers without going into evidence, and we want to equate the two of them. The shoe is not the other foot. This is a slipper. This is not apples and apples. This is an apple and a dunks. But to come in here and try to mislead people, to mislead the commission, to mislead the public of Barbados who they say they're representing is unfair. And I take personal umbrage, sir, and I want it to be recorded that any counsel will seek to conflate the death of a colleague's father as part of a strategic basis of an adjournment. Extremely unfortunate language. And there, for the grace of God, any of us, sir. And sir, I apologize if I'm getting a bit thing, and I do apologize to the commission. I know I've been warned already in terms of my tone, sir. So I'm just gonna bring it down a bit. The simple fact is this, sir. The parties did not benefit from having a previous gathering to discuss available dates, and no one is seeking to blame anyone for that. I think what is a common theme coming out of the arguments is that perhaps a technical conference, given the issues relating to the factors to be considered in a review, may prove useful to addressing the various concerns that have been raised by all the parties, and will go a long way to assuage any concerns that have been raised with regard to the hearing of the matter, time for parties to put their house in order, and how best the position on a review, which, sir, I did not take part in the preparation of the documents, and when I'm looking at it, it's extremely technical with regard to the concept of retroactive rate making, et cetera. Those are my substantive submissions in response, sir, unless there was anything particular on which the commission wished to hear me on, sir. Sorry, you're muted, Mr. Chairman.
Mr. Boyce, I've heard your submissions, but in your reply, you did not give any consideration to the fact that some of the other applicants, some of the interveners would not be available between June 26 and July 21. And you have not addressed that in your reply.
Yes, sir. The applicants in relation to Mr. Wendt, I believe, and Mr. Skeet, sir, are representatives in the class action, which I will be partaking in as a legal representative, sir. There are also 300 other persons who are part of that class action. And I don't think I will be telling tales of the school where the next days, the days around the 26th are to be occupied by cross-examination of certain bank officials and valuers. So one, there'll be other persons to assist with that action who can assist Mr. Skeet and Mr. Wendt, and they are also have given their evidence in the matter, so they will not be required to take part as such, sir, in the actual hearing. I believe those were the only two persons who had expressed concerns about the time period.
I'm having a little bit of difficulty in understanding your submission in the fact that if we're to consider the motion and looking at the merits or the merits of the said motion, that if persons in their objection have raised their challenge with the dates of June 26 to July 21, you're indicating to us that we could just go along with, let's say we were mindful to look at it, that we should just go along and ignore the other because they're able to get someone to present them. That is your submission?
No, sir. I am saying that as set out, I was drawing reference and I had made the assumption that Mr. Chairman, I was referring to the correspondence sent in by Mr. Wendt, sir, in response to our communication, wherein he had expressed those concerns. And in his communication, the stipulation was that we are both involved in a matter which is proceeding before the High Court, sir. And I'm saying, sir, that involvement by Mr. Wendt has already occurred substantive. His substantive participation, sir, has already occurred in relation to giving of his evidence, along with Mr. Skeet, who have given his evidence. And in the situation where the parties are being heard, they are not required to be in attendance. there are persons who, if there is someone necessary to attend out of the 300 persons involved in it, who can attend if they are required to be at the FTC hearing, which Mr. Aline will be at, sir. Go ahead, Jim.
Now, I was looking at the oral submissions today, and Mr. Skeet, as well as Mr. Wen, did indicate, and in their submissions, they had also challenged the fact that you may have resources, just as you are now saying that they may have resources for those particular dates. So it is that in terms of you did not address that in your rebuttal. The fact that you're saying that they can find resources or find individuals to represent them. I'm hearing also the submissions of the interveners that likewise like Empower. So I'm saying you have not addressed that.
Thank you, Mr. Chairman. Yes, I am totally with you. The resources required to observe a civil trial, sir, would be disproportionate to compare the resources necessary to bring legal counsel up to speed to argue, and I'm now pulling it up here, sir. The review that was filed in excess of some, well, it's not numbers, sir, but I will go with 105 paragraphs, sir, in relation to the points raised and the legal matters which have been addressed in terms of the law, particularly retroactive rate making. The concept, sir, that because the firm is large, we slide an attorney in to replace Mr. Aline, certainly upon short notice. I think with an understanding of how things work, one, you have to look of the experience which Mr. Aline has, being a King's Counsel, over 30 years practice, having argued a rate hearing previously, sir, to be able to conduct the nature of the arguments. Case in point, yourself, Mr. Commissioner, you have two King's Counsel who are advising you on these matters. The ability, therefore, to get a team member up to speed will require a bit more effort as opposed to having someone observe a civil trial that is ongoing. Let's say the firm were playing a role in this hearing wherein we just needed to have a note taken. Well, then certainly, sir, we can have someone deployed in Mr. Aline's absence. Given the sophistication of the arguments, while I am flattered with the thought that I could do them, I'm pretty sure I can. However, I would need a certain amount of runway. I believe, sir, that this matter would have been filed since the 7th of March, 2023, with all the necessary parties getting their house in order and having the opportunity to review. Given the fact that the commission, having considered everything and with the guidance of their legal counsel, made a reasonable assessment that 3 months should be enough time to get everything in order, it would be a bit unfair if the interveners were to think that, as capable as I am, that could be done within the period which is set down for the 13th of June to the 15th. So just to be clear, sir, one, it's a question of what is required in the trial by the interveners. I am in no way selling short the contribution. Mr. Wendt, I always say, sir, he's one of my favorite witnesses to cross-examine. He will tell you, sir, that I cross-examined him and we had an enjoyable cross. And Mr. Skeet, sir, in terms of the evidence, having given the evidence, sir, their role, of course, is to observe. They can't make suggestions and that type of stuff. So given the nature of that role, sir, their attendance at the trial, one, is not a requirement. Two, there are other persons who can represent their interests. And three, they can always get the updates as the matter goes because there are other persons and they are represented by counsel. Not as good as Mr. Aline, but they are represented by their own KC, sir. In these circumstances, sir, it is a bit different from saying, well, can Clark Giddens Farmer get someone else to argue this case? Yes, we can, but we cannot get someone else to argue the case in the time period. And the applicant, as you would recognize, sir, ought to have the benefit of having the counsel who has been in this matter for the past 4 years. Mr. Alleyne has personally championed this matter. He was there from the filing, sir, when the original steps would have been taken, and he ought to be the one to put it to bed, to say, sir. So in these circumstances, I think when we consider all the factors, I think while I understand the argument of my friends, I think it'll be a false equivocation to equate the two levels of contribution that would be necessary. Have I touched on the question, sir, or do I need to?
I was just mindful to the fact that the information that was presented by the interveners in terms of rebuttal for your proposed dates, that you did not address that in your reply. So I just wanted some clarity in that area. Okay.
Thank you, sir.
Thank you. Mr. Simpson, Mr. Simpson.
Good afternoon, everyone. Chair, I think we were a bit over our time earlier, and I know others have submitted dates. I just wanted to put on record that I am not available between June 17th and 30th for similar reasons, prior schedule overseas business that I cannot get out of, unfortunately. The 14th to 16th, while inconvenient, I can make work if that were the decision. But definitely the 17th to 30th of June, I am unavailable. Thank you, Chair.
Okay. Yeah.
If I may, sir, just in terms of, we didn't anticipate it would be required, but there is a legal authority for the principle of you're allowed to have the QC that you want to argue certain principles, and we will undertake it to share. So sorry, sir.
Not available, June. Okay, Ms. Watson, I note that your hand is up, but remember that you did make your submissions. I hope that if allowing you would be just to indicate a date or something like this, but not to make a submission at this time. So can I hear your query or?
Mr. Chairman, thank you. I have raised my hand. I actually did want to put another matter of timing and delay on the table while we're here, and that is in relation to the long delayed compliance filing that the applicant says it has filed with the Fair Trading Commission, but has not been served on interveners some 95 days later. And we are still waiting for it. And we have written to the Fair Trading Commission. requested that. The law demands that it is served on us, and it has not been. I'm asking you, Mr. Chairman, to direct the applicant today to file that, to serve that on us by Tuesday of next week. And the stay, Mr. Chairman, does not affect that compliance filing. Mr. Chairman, I want to speak
Ms.
to.
Watson, and I just don't want us to get into issues that are not before us today in relation to the motion. So I really
understand, Mr. Chairman. I just want to flag that because that also is adding to the delay in this matter, and that is the impact that is causing that. However, Mr. Chairman, while counsel for the applicant, Mr. Boyce, made his very emotional statement, he made a statement in relation to other counsel, or rather counsel. Mr. Chairman, I have to address this because it's important.
No.
Go ahead. You cannot just run the show.
Miss Watson, I just want us to be clear.
I understand you, Mr. Chairman.
Of dealing with the respective motion before us, and you would have made your submissions, and I don't want us to be debating that. So
Mr. Chairman, will you allow me to respond to an incorrect statement that was made by counsel about me?
Miss Watson.
About me, Chairman. So, Chairman, I just want what he said to be struck from.
No.
Miss Watson.
I will have to write about it, Mr. Chairman. It was a defamatory statement.
Okay. Okay. Good to make a contribution, please.
Okay. Oh, you heard it.
Mr. Wayne?
Yes,
You wanted
Mr. Chairman. Yes, I want to make a thank you for giving me the opportunity. Mr. Chairman, just very quickly, there were Senator Boyce, didn't make the point that we have 300 plus members. But remember, we being Doug Skeet, Philip Osborne, and myself are the claimants to the action. So we're the persons who signed the lawyer on board. So we're the persons that represent, and then we brought people on board, through various meetings. Therefore, we have 4,515 pages that we've been giving both financial, technical, and other support to our council. Remember that I'm the only person of the group who would have worked as an executive of Cable Wireless. So I've been at every single hearing on this matter. There's no hearing. Yeah, I've canceled vacations, all kinds of things, because we have taken money from Minority Shield. So that's one. The other thing I'd want you to take into account as well is that we are absolutely ready. Haven't had 5 years. We can't afford to have our now valuation expert BDO impacted because they're already costing us. They had to change their dates, and therefore that period, I'd like respectfully to ask that period will be 26 to 21st July be blocked out completely. That would allow us freely to be able to do the class action. So I really would appreciate that. And this would apply to both Doug, myself, and Philip is not on this one, but we're the actual claimants to the matter. And finally, Mr. Chairman, I'm sure that you didn't take Ray's comment seriously that the interveners will not be part of it, so I wouldn't even touch that. And I'm sure the commission is well aware that the public have their eyes on this matter. So when the time comes, the motion to review that decision will be held as a public hearing. So we know the commission is well equipped with those things. I just want to let you to be aware of those, Mr. Chairman, that we have, yes, 300 members, but Doug, myself, and Philip, and the claimants, we've been at that, and I've been in there every single day. Thank you, Mr. Chairman.
Okay, thank you. And just to emphasize that from the outset, we did indicate that the hearing will be an oral hearing. And yes, it will also be a public hearing. So that has been determined. There would be no written hearing in this matter. It would actually be an oral hearing. So we have heard your submissions in relations to the motion, and we will now adjourn so that we can, yes, Mr. Worm, before we adjourn, if you want to make a submission in terms.
Thank you, sir. I just wanted it to be clear. I've heard it twice. That it has been Brea's recommendation that we proceed without the interveners. I want it to be clear that Brea has said that we would expect that every attempt would be made to make sure that everybody is available. But as we speak and continue to speak, there are going to be more and more conflicts. And all I'm saying is that at the end of the day is our position. We may be one of those that may not be available because I do have to travel as we get later on into the situation. People are going to be traveling, and I don't know how long we can continue this. So our position is that while we make every effort to ensure that all interveners are available, the important thing in my view, because at this stage we have given all of a lot of our contributions, others may have more to offer, and therefore we may want to work around them. But our position really is that we have to move ahead with this for some of the reasons mentioned by other interveners. So I just want to make it clear that it is not our position that we should just decide to move ahead regardless. So I just want to be clear, and I'm surprised that that was how it was actually interpreted, but maybe my fault. Thank you.
Okay, we've heard the submissions, and we will now recess, and we will resume hopefully by 4:15, by 4:15 to give a determination on the matter that is being, on the motion before us.
Mr.
So we
Chairman,
have a
Mr.
recess.
Chairman, we'll be using the same link, I presume.
Yes, please.
Yes, okay, all right, I'll be in office.
Thank you, Mr. Chairman.